I'm muted. I'm ready. Thank you. I would like to announce that the recording has now started. Operator, you may begin whenever you are ready.
Our CenturyLink
Hello,
operator.
it's the operator.
So sorry, Chairwoman. Orlando, if you're available, please go ahead and start the script.
Today is Tuesday, February 15th, 2022 at 12 p.m. Eastern Time. Welcome to a web briefing of the North Carolina Advisory Committee to the U.S. Commission on Civil Rights. This briefing is being recorded. Present on today's call are staff from the Commission and members of the North Carolina Advisory Committee. There may also be members of the public on the line who will remain in a listen-only capacity until the end of the briefing. I will now turn the briefing over to the Chair of the North Carolina Advisory Committee, Olga Morgan-Wright.
Thank you very much, and good day to everyone. I am Olga Wright, Chair of the North Carolina Advisory Committee, and I thank everyone for joining today. I will now take the roll call. Daniel Bose.
Present.
Pearl Burris-Floyd. Travis Cook. Christopher Duggan.
Present.
Marcus Gregson.
Present.
Stephen Green.
Present.
Jonathan Guzay.
Here.
Jennifer Lechner.
Present.
Angelo Mathey.
Present.
Patrick Mincy.
Present.
Donna Oldham. Catherine Reed.
Present.
Mercedes Rester Chocklin.
Present.
Gregory Wallace.
Present.
And Bradley Young.
Present.
Thank you all. I would like to make a few announcements. The United States Commission on Civil Rights is an independent, bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws. In all 50 states, the District of Columbia, and the U.S. territories, an advisory committee to the Commission has been established, and they are made up of persons responsible who serve without commission to advise the Commission, without compensation, to advise the Commission on relevant information concerning their respective jurisdictions. Today, our purpose is to hear testimony regarding legal financial obligations in North Carolina and related civil concerns. This is a continuation of the study that was initiated by the North Carolina Advisory Committee in 2020. Though some of the statements made today may be controversial, we want to ensure that all invited guests do not defame, degrade any person or organization. As the chair, I reserve the privilege to cut short any statements that defame, degrade, or do not pertain to the issue at hand. Given that we have a lot to cover today, and out of respect to our invited speakers, I want to note that we will abide strictly to the time limits for each speaker. Panelists will have 10 minutes for prepared remarks. Committee members have 1 minute to ask a question, and members of the public will have up to 3 minutes for their comment. Speakers will be notified when their time is almost up. I reserve the right to request that a speaker be muted after your time has ended, and I have provided 2 warnings. Based on the proceedings, the committee will prepare an advisory memorandum to the United States Commission on Civil Rights, detailing findings and recommendations for addressing the issues that are most important to us. This report will be available for public review, and we are grateful to all speakers for their willingness to share their experiences with us today. At the outset, I want to remind everyone present of the ground rules. This is a public meeting, and remarks will be recorded and transcribed for public record. We have a full schedule with limited time available. After hearing from each speaker, I will use our roll call list and ask each committee member if they have a question for the panelists. Committee members will be given 1 minute to ask their question. As time permits, I will use the roll call to ask if there are any follow-up questions. Please also note that the chat is intended to be used only if logistical or technical issues arise. All messages will be sent to the host. To accommodate persons who are not on the agenda but wish to make statements, we will ask for public comments toward the end of today's meeting. We will go in the order of any public speakers who registered in advance. 3 minutes will be allowed per speaker. If time allows, any members of the public who did not register but wish to provide comment will have opportunity to do so. After public comment, if time allows, we will revisit any final committee questions. In addition, written statements may be submitted by March 17, 2022 to Liliana Schiller at lschiller@usccr.gov for inclusion in the public record. Today, we're scheduled to hear from 3 panelists: the Honorable Andrew M. Gregson, Judge Thomas H. Locke, and retired Judge Denise Hartsfield. We will begin with Mr. Gregson, District Attorney of Randolph County. Mr. Gregson, you have the floor for 10 minutes.
Thank you so much, ma'am. Members of the committee, thank you for the opportunity to address you and to answer your questions. I hope my remarks, my answers to your questions will help you in your important work. First of all, it's impossible for me to discuss this issue without the context of recent events. It is undisputable that government itself caused some of the financial hardships that members of the public, especially those in the criminal justice system, find themselves in. And I really think, respectfully, your committee should look at the role of government these past 2 years in causing our citizens this hardship. Whole industries, at least in my community, were shut down for extended periods or had their operations severely limited. And this caused many in our community to lose their jobs. To make matters worse, government was not prepared for the number of claimants for unemployment, and it was not uncommon for our citizens to wait 4 months or more to receive any financial assistance. Many of the businesses closed did not survive, or they're still struggling to recover and hire their workforce back, especially industries that hire people on the margins that we often deal with in the criminal justice system. This obviously has caused tremendous burdens on the court system over the past 2 years and continues to cause problems. Persons who had previously been making all their required payments were now simply unable to do that. And I can tell you that prosecutors, judges, and probation officers, at least in my district, have shown unrelenting mercy to these people who found themselves non-compliant through no fault of their own. For example, in my district, I personally ordered my prosecutors to automatically agree to long continuances when the defendant simply came in and said they had been laid off or let go because of the COVID shutdown orders. Countless hours in court had been spent on these cases to work out solutions on a case-by-case basis. And usually the end result is we simply struck a lot of the financial obligations. This unilateral decision, oftentimes unilateral, to throw hundreds of thousands of our citizens out of work and not being ready to process their unemployment claims, unfortunately, was very disastrous to especially those members who we often deal with in criminal court. Government operations as a further problem being shut down, such as a good example is DMV, often made compliance either impossible or almost practically impossible, even if the citizen had the financial means to comply. This committee should recognize that the offender's personal responsibility, however, for willful choices should not be ignored or discounted. It's not unreasonable, in my opinion, to ask citizens to be aware that committing infractions or crimes will carry financial consequences. And if you're unable to afford those things, it is reasonable to take that fact into consideration when making choices about your conduct. Having said this, I can say that every prosecutor and judge that I'm aware of, we are fully aware of the financial burdens imposed in criminal matters, and it is a matter of root that we act appropriately to try to assist citizens. I also want to stress that no one in the system looks at financial obligations as a means to fund any part of the system. No one I know thinks that way. If anything, there is broad consensus that in some respects, these financial obligations have become excessive and unfairly burdensome. Prosecutors routinely craft plea bargains to limit court costs, fees, and fines. We routinely consolidate cases in order to limit these and agree to greatly reduce fines when the citizen's ability to pay is limited. Like I said before, I've instructed my prosecutors in traffic court, for example, over the last 2 years to routinely cut our normal fines to just a few dollars. When the sentencing judge is oftentimes considering striking probation supervision fees or other costs, my prosecutors do not object. Prosecutors, probably the biggest impact is that we have continued many cases for months at a time to give the citizen time to get their required money, even in infractions. It's not uncommon in my district for us to continue traffic matters for 6 months, and it's not an insubstantial amount, up to a year, so that they can fix their catalytic converter or comply so that they're in compliance with the law. However, I want to stress after reading your report that restitution is and rightfully should be treated very differently. Oftentimes, restitution paid by the defendant is the only way an innocent victim will receive any recovery for their loss. My prosecutors routinely argue for severe consequences for failure to pay restitution, and I'm not going to apologize for that. The defendant harmed the victim and bargained with the state to make the victim as whole as possible with full understanding of their obligations. They chose this bargain oftentimes to avoid an active sentence of imprisonment, and I expect them, if at all possible, to live up to their bargain. I will say that judges, I know we're going to hear from a couple of judges, but they routinely attempt to help offenders with these financial obligations. It is extremely common for the sentencing judge to ask the defendant about their ability to pay, and also to ask, do you need additional time? It's also common for the judge to strike cost of all manner, and I cannot think of a time when my prosecutors have objected to this. I think you probably know that North Carolina law does not allow for the easy revocation of suspended sentences for failure to pay these obligations. The defendant is entitled to 2 separate hearings for any violation other than commission of a new criminal offense or absconding. My prosecutors, when I surveyed them, cannot remember the last time an offender was revoked for failure to pay. Oftentimes, the judges simply terminate probation unsuccessfully without revoking them. This committee should also respectfully consider that some of these financial obligations are properly and necessarily punitive in nature because the criminal conduct resulted in serious harm to another citizen or posed the potential for such serious harm. I offer to you as an example, driving without insurance. Seems on its face to be not very serious, but every day we see terrible consequences where there is financial ruin for victims injured by a driver without insurance. I can think of a case of a CPA who had to declare bankruptcy, who was run over while bicycling and suffered traumatic head injuries, couldn't pay his bills because I think you probably know it's easy to exceed the state mandated uninsured, underinsured coverage. These types of financial obligations are necessarily punitive, and I think rightfully so. However, it is my opinion that some of these financial obligations may be excessive when you compare them to the cost of the state to deal with the conduct and the absence of any valid punitive or deterrent considerations. For example,
so you have 2 minutes. Excuse me, you have 2 minutes left.
Thank you. For example, restoration and failure to appear fees that the North Carolina DMV imposes oftentimes seem to be, I think, out of the bounds. I personally believe there's nothing wrong with a thorough examination of our financial obligations imposed in criminal court, as long as we take into consideration the factors of deterrence, punitive interest, and cost of the state. Those are my comments. Thank you so much.
Thank you very much for your informative. And we will now go to, the committee, and I will go down the list of our committee members for questions. Please be reminded that you will be allotted 1 minute for your question. And I will begin with Mr. Daniel Bose. If you have a question.
Yes, I have one question. Let me first thank you, District Attorney Gregson. That was a robust statement, and really appreciate you differentiating between fines, restitution, and court costs and some of the other statements. You mentioned that your go-to was, to start out when somebody indicated their inability to pay, that they would start with the continuance. But ultimately, a lot of those individuals who were given a continuance could not end up paying, and termination and probation was terminated without those individuals paying the fees. And so could you just talk about what the dynamics of that look like? Like, what are you hearing about when people say, I can't pay? And what is that standard? Like, is ability to pay mean that, or inability to pay mean you don't have any money at all? Or in Randolph County, does it mean you don't have enough money to pay for your, groceries and childcare? I'll stop there, but thank you.
Mr. Bose, that's a good question. It varies judge by judge. I will say that most of the judges conduct a very thorough examination when the offender comes in on a violation. There's a lot of questions about what your expenses are, who do you live with, what fixed expenses, do you have expenses like child support that we're going to give priority over court costs and fees and fines. So it starts with a very thorough examination by the judge. Takes a lot of time, but usually the defendant is prepared to answer those questions, or the lawyer is. And I would say it's not unusual for us the last couple of years with the economic problems we've had to see multiple hearings like that. And so usually at some point when supervision has run out or is coming to an end is when the judge has to make that decision. So I think we give them, it's hard to give you an exact amount because every case is different, but it's not unusual to see people come back in Superior Court, for example, 2 or 3 times for their financial obligations. The probation officers are very understanding, but their internal regulations require them to bring the offender back to court before supervision runs out. So that's usually the impetus for those hearings. But the judges do a really good job, and I think the other 2 judges can answer that better than I, but we're spectators usually in that. But they do a really good job of asking some hard questions about what fixed costs the offender has.
Thank you, sir, for that response. So we will move on to our next committee member, Pearl Burris-Floyd. Do you have a question? Ms. Burris-Floyd, are you on the line? All right, we'll move on to Mr. Travis Cook. Do you have a question?
Not at the moment, ma'am.
Thank you. Christopher Duggan, do you have a question?
Yeah, just a quick question. And I echo the thanks, District Attorney, for coming today and appearing here and providing us this information. Do you see, when you're dealing with the public and the offenders, that the impact that the fees and fines have had on the individuals is towards one group or another, or can you classify it as to who it affects greater than others? You understand what I'm asking?
I do, Mr. Duggan. Thank you. No, the answer will be no. the court costs, the fines, the fees are imposed across the board in a consistent manner. As far as impact, yes, the last 2 years, the people on the margins, the people in restaurants and service, retail type businesses that were shut down, there's been a disparate impact on them, sure. As far as the general public, even the people that can pay, we hear a lot of complaints that they're too high, whether they can pay or not. They're basically, you know what we hear. It's fundraising. It's the state getting paid. I mean, we hear that everywhere we go. The local agencies are getting a part of it back. You can imagine what we hear, but the judges are very uniform in the way they apply these, but it has had a disparate impact on the people who were affected by the COVID shutdowns the last 2 years, no doubt.
Thank you, sir.
All right. Thank you very much. We'll move on to Mr. Stephen Green. Do you have a question?
First, I just again wanted to reiterate everybody thanking you. Really thoughtful, interesting comments. My question was about you talked about in terms of reconsidering these, the need to consider the deterrent effect. And I was just wondering from your perspective, for you to elaborate on that a little more in terms of if you were able to really, you felt like you could really see the deterrent effect of these types of fines and fees.
Thank you, Mr. Green. Yeah, well, especially in speeding cases, I think the state has reached the point that if you come in and pay a speeding case, there's a deterrent effect for a while. As far as your criminal cases, that's hard to say because sometimes we don't get to see the end result, but I can tell you that it probably does have a deterrent effect because we do hear the offenders talking about the cost. They have to make sacrifices sometimes to make those costs. So it's kind of a mixed bag, but I think as far as things like speeding, there is a definite deterrent effect.
Thank you, sir. Mr. Jonathan Guzay, do you have a question?
Oh, yes, I'll try to be quick. Mr. Gregson, you've talked about some of the legitimate purposes that these fines and fees serve, including punishment, deterrence, and restitution. I just wonder, have you ever seen, in your experience, is it possible to use these in a way that helps with rehabilitation as well by encouraging compliance with supervision and that sort of thing? Just, I have no idea what the answer is. I'm just curious. Thanks.
Is it Mr. Guzay? I'm sorry, sir. How do you say your name? I'm sorry. Mr. Guzay. Mr. Guzay, that is a good question. I really don't know how to answer that. I think there is some benefit to some of the cost, having some skin in the game, especially as it relates to treatment and things like that. The other fees, fines are not really designed for that sort of thing, so it's hard for me to answer that. The judges may have a different perspective, but it's a good question. I will say that there is some benefit in an offender paying restitution. That's oftentimes the gateway for them to get back into that social circle of friends or family. We see a lot when there's family victimization where someone's broken into a family member's house and taken things. There's a lot more ability for the family to forgive if restitution's made.
Thank you very much. And we have next Jennifer Lechner. Do you have a question?
Yes, thank you, Chairwoman, and thank you, District Attorney Gregson, for joining us here today. As I'm sure you're aware, this topic has garnered a great deal of attention in many different fora, including this one. And I'm wondering if you could talk about both in your jurisdiction, but also with your work through the Conference of District Attorneys, the use of Form 415 that's been promulgated by the Administrative Office of the Courts, and whether that has been helpful in considering the ability to pay, after restitution, fees and fines have been ordered, and have that kind of reconsideration of ability to pay, especially as you've noted during the last couple of years of economic hardship.
Yes, ma'am. I don't know if the forms made that much of a difference because I think we were already doing what the form lays out. And I think it's important to understand why we were doing that. No one in the system has time to set people up for failure. Because if you set them up for failure, you just have a revolving door of hearings, which are already very labor intensive and taking our time in valuable time in court away from disposing of cases, which we've also got a backlog because of the COVID shutdown. So I think the judges have done a really good job in my district of being aware that we don't want on the front end set someone up to fail. It doesn't help anybody. And so what I've witnessed and my prosecutors, when I surveyed them in preparation for this testimony, has witnessed the judges really listen to the lawyers and to the pro se defendants if they say, I'm not working, or I just started a new job, or whatever information they give the court. The courts have been doing a good job already, and that was probably because of the COVID shutdown.
Thank you very much. And so I will ask my question now. I would like to know, do you have any recommendations for any type of restitution other than fees and fines? Would you recommend any other type of deterrent?
You know, ma'am, for a long time, I've studied this for a long time. I'm also a business owner, and I believe you have to incentivize the type of conduct you want. There's no difference if an offender comes in and pays on the first setting or the 10th setting. And if it goes to the 10th setting, the state has incurred a tremendous amount of money through setting that case 10 times, 12 times. And it just seems to me to make sense that if the system could incentivize early payment at a reduced rate, we might actually come out to the better for the offender and for the state, because there is a tremendous amount of resources. I'd love to see a time study when we continue a case in district and superior court over and over and over again. That case has to be calendared. It has to be calendared by the clerk, calendared by the DA. Subpoenas go out to all the witnesses. There is a tremendous amount of resources the state spends. And what we've tried to do is to, instead of continuing a case 1 month at a time, we've started when we know someone is having trouble, we continue the case out 3-6 months at a time, because we know they're just going to be back in the next month saying the same thing. So I wish the system had the ability, like business, to incentivize the type of conduct we want, and it would actually allow the offender to pay a greatly reduced cost and the state still come out to the better, if that makes any sense.
Yes, sir. Thank you very much. And we'll go next to Angelo Mathé. Do you have a question?
Yes, thank you so much, District Attorney Gregson, for taking the time out of your schedule to speak with us today. My question was more of just a clarification question, or I think for me, I wanted just clarity on, you talked about the judge's role in helping determine an individual's ability to pay these fines and fees. What, if any, are the practices within your jurisdiction that DAs deploy when striking these plea bargains and inquiring about an individual's ability to pay?
Okay, good question. If there is counsel in the case, the counsel typically come to us to see if we will agree to their motion to strike or to give additional time. If the person is representing themselves, such as traffic court is the most common scenario, we always ask the offender if there's anything they want to tell us. And that's usually when they start telling us about being laid off, losing their job, whatever. And they have a blanket authority from me to give continuances liberally in those situations. Our only real role with the judge is to either not object or to join the counsel's motion. And we do that pretty routinely.
Thank you very much. And I just want to say we have 6 minutes left in this frame, so we'll move it along very quickly. Mr. Patrick Mincy, do you have a question?
Good afternoon, Mr. Gregson, and thank you for your time and testimony today. My question is based first on a comment that you made, and this committee has addressed before, which is a general criticism that various administrative costs are passed on to individual defendants, essentially in support of operational costs within the court system. If you accept that criticism is generally true, what in your experience and what opinions can you offer with respect to improving upon that situation? How can the legislature better fund AOC directly so that any alleged disparate outcomes are taken away? In other words, isn't this really an issue when we're talking about administrative costs being passed on disparately to different individuals at different rates, taken away if the legislature will better fund the administrative office of courts?
Okay, I'm going to agree with you, Mr. Mincy. I think you're exactly right. I'm a small government conservative, but I think that government ought to be funding things that it should be doing, and the court system is one of them. So I think you're exactly right. I think there is some valid criticism of that. I think that one of the things that hamstrings us a little bit is the constitutional obligation of fines to go to the school system. And there's no way around that save a constitutional amendment. But I take your point. I think we'd probably agree on that.
Thank you, sir.
Thank you very much. Ms. Oldham, are you on the line? All right, we'll move on to Ms. Catherine Reed. Did you have a question?
Not at this time, thank you.
Thank you. Mercedes Restu-Chaklam, do you have a question?
Yes, thank you so much, DA. Thank you. There have been so many excellent questions that I wanted to ask about. You touched upon a little bit. You mentioned briefly a time study, and we've heard testimony before that the large majority of fines and fees that are assessed go without being paid, right? So our government's not really relying on those fines and fees because the large majority are not really being paid. And then you've also mentioned the amount of time that's spent assessing and having people come in because of failure to pay and the number of settings that's being given. Can you do you think you could estimate about how much time you use and your DAs are spending associated with fines and fees?
That's a really good question. It's hard to quantify. I will tell you that if you look at the statistics for every Superior Court session and District Court session, a percentage of those are going to be continuances, and a significant reason for a lot of those continuances are going to be the inability of the defendant to pay, especially in District Court and in Traffic Court. Our continuances in Traffic Court have gone up. I can tell you just anecdotally, they've gone up significantly, and I would say the vast majority of the reasons is failure to pay. That's at least in Traffic Court. I can only speak to Traffic Court probably with some confidence.
Thank you.
Thank you very much. Mr. Gregory Wallace, do you have a question?
Yes, I do. Thank you, Mr. Gregson, for spending your time with us. And I really appreciate my colleagues here for all the good questions that they have put forward as well. One of the questions that I have is about the question of credibility when people make claims of inability to pay. I'm sure there are people who don't want to pay and just claiming that an inability to pay is rather an easy way out for them. What do you require in terms of entering into plea agreements and other efforts in terms of how do you know when a claim of inability to pay is credible?
That's a really good question. It is a case-by-case basis. Sometimes if the probation officer is present, that's a good check to know if they're telling me the truth. Here lately, if they claim in negotiations they don't have a job or they got laid off, if they can prove they were working at a place, it's public knowledge. Has that place been reduced hours or been stopped? So it is largely at times a matter of trust. And they know that if they lie to the court, there's going to be significant consequences. That's probably the biggest deterrence. But I would say in probation matters, the number one piece, the number one actor that helps us make that determination is the probation officer, who knows more than anybody in the courtroom about the offender.
Thank you very much. We are adding a few more minutes. We're at 12:38, trying to stay on time, but we do want everyone to have the opportunity. We have Mr. Bradley Young. Do you have a question?
He just answered it, the question before, so I'll cede my time back.
Oh, I'm sorry, I was talking so much. I didn't realize I was on mute. I was saying thank you, sir, very much for your time and your very informative questions. I'm hoping that that will allow us to fill in some of the blanks here. And we will move on now to our next speaker, who is...
Ma'am, I wonder, did Professor Gadsden get an opportunity to ask a question?
We've taken care of that, sir. No, he's not on the line anymore. Thank you. We will now move on to our second panelist, who is, Judge Thomas Locke. You have the floor for 10 minutes. Thank you.
Thank you, Madam Chair and members of the council. I'm certainly honored to be with you this afternoon. I thank you for addressing the impact that legal and financial obligations of criminal judgments can have on defendants. And I want to commend you for your decision to solicit the perspectives of some of us actively engaged in the judicial system and charged with the responsibility of imposing those obligations as a part of our judgments. As you may know, the superior courts of our state are the highest trial courts. Resident superior court judges serve 6-month rotations among the various judicial divisions within the state. There are 5 divisions, and we are subject to assignment anywhere in the state. Thus far, I have held court in my 15 years on the bench in 55 counties. I have served a 6-month rotation in Mr. Gregson's district, and I've held criminal court at least twice in Forsyth County, which is Judge Hartsfield's district. To date, I have presided over 300 jury trials, and I have adjudicated several thousand guilty pleas and probation violation hearings. My comments this afternoon are not based on any empirical research, but they are based on my many years of experience across the state and my conversations with my colleagues on the bench, with prosecutors, and with defense attorneys. More important, I believe they are accurate. First, I am compelled to state that many of our court costs and fees can be onerous. Basic superior court costs are $355.50. Community service fees are $250. A failure to appear fee is $200. And jail fees are $10 per day pre-trial and $40 per day under a split sentence. Yes, we charge people for the privilege of spending time in our jails. The crime lab fee for analyzing the evidence in a drug case is $600. Probation supervision fees are $40 per month. An electronic house arrest carries an installation fee of $90 and a daily monitoring fee of $4.48. For indigent defendants, and most criminal defendants are indigent, the basic appointment of counsel fee is $75. And added to that is the actual attorney's fee, ranging from $65 to $85 per hour. And I haven't even mentioned fines or possible restitution to crime victims. Clearly, a poor person can scarcely afford to run afoul of the law. And these are the fees for those defendants who are fortunate enough to avoid prison. Frankly, most defendants avoid prison, at least for their first several convictions. These are the fees for those defendants who receive suspended sentences, which in superior court usually include supervised probation. However, you must understand that there is a chasm between the costs and fees authorized by statute and those actually imposed, much less collected. Judges are keenly aware of the financial burdens associated with criminal judgments and routinely act in such a fashion as to mitigate those burdens. Fines are seldom imposed, except in drug trafficking cases for which they are mandated and for driving while impaired. Costs and fees often are waived at the front end, that is, at the time of judgment, or remitted later, such as at a probation violation hearing. Jail fees and probation supervision fees are the types of costs often waived. Basic court costs, fines, and attorney's fees are the types of cases, or costs rather, often remitted. The law prohibits the outright revocation of probation except in cases of a subsequent criminal offense or absconding, and judges seldom impose any period of confinement merely for non-payment of court indebtedness if the offender has made any effort at all to pay it. In fact, our statutes expressly require us to consider the ability of criminal defendants to pay. In imposing a fine in CGS 15A-1362 subsection A provides that, quote, the court should consider the burden that payment will impose in view of the financial resources of the defendant. NCGS 15A-1563 provides that a judge may remit or revoke in whole or in part a fine or costs whenever, quote, it appears to the satisfaction of the court that the circumstances which warranted the imposition of the fine or costs no longer exist, that it would otherwise be unjust to require payment, or that the proper administration of justice requires resolution of the case, close quote. I think we would all agree that whenever possible, criminal defendants should be required to make restitution to the victims of their crimes. But even in those cases in which the court orders restitution, NCGS 15A-1340.36, subsection A states that, quote, in determining the amount of restitution to be made, the court shall take into consideration the resources of the defendant, including all real and personal property owned by the defendant and the income derived from the property, the defendant's ability to earn, the defendant's obligation to support dependents, and any other matters that pertain to the defendant's ability to make restitution, close quote. I will, in passing, mention the docketing of monetary obligations as criminal or civil judgments against offenders. This issue is complex and frankly beyond my ability to address it adequately in a whole day, much less 10 minutes. Suffice it to say that as a general rule, fines and costs should be docketed as a civil judgment only when ordered in writing by a judge, and unpaid restitution should be entered as a civil judgment only in Victims' Rights Act cases, and only when the restitution amount exceeds $250. Such judgments become a lien on the real estate of the defendant. However, the state seldom attempts to execute on such judgments, and most criminal defendants don't own any real estate. I do also want to mention this new form that was asked about a few minutes ago, Form AOC-CR-415. This form is a pre-printed motion and order for relief from fines, fees, and other monetary obligations. It is 4 pages long, and pro se applicants would need the assistance of an accountant to complete it. Moreover, I am confident the judge cannot complete his or her part without the aid of the clerk. I have yet to see this form in a case before me. In practice...
So, I'm sorry, excuse me, you have 2 minutes left. Thank you.
Thank you. In practice, the waiver, emission of fines, costs, and other legal financial obligations happens quickly and on oral motion. In summary, it simply is not true that the legal and financial obligations associated with criminal judgments are some sort of debtor's prison, or that they are imposed by a judge without first inquiring into a person's ability to pay and without considering whether there are adequate alternatives to imprisonment. I also challenge the notion that such obligations are discriminatory against persons of color, except to the extent that persons of color are disproportionately misrepresented or represented in the pool of criminal defendants for reasons that are beyond the scope of our conversation today. But these obligations may be excessively punitive, especially for lower income individuals. And I do, again, applaud your discussion of this issue. Thank you.
Thank you, sir, very much for your informative information. And I will now move on to our committee and ask if there are questions. I will begin again with the roll call and start with Mr. Daniel Bose. Do you have a question?
Yes, ma'am. Judge Locke, thank you very much for a highly informative presentation. I just wanted to try to connect a few dots here. I appreciate you running through the list of fees that you did. And also, if I heard you correctly, you have presided in court in 55 counties. And so I think you're uniquely situated to talk about if there are different cultures by county. And I hear a lot of it comes from the clerk's office, where they'll sort of pre-fill the cost, and it just depends on what county you're in. And my specific question is particularly around sort of access to justice issues where it's a pretrial fee, for example, electronic monitoring, where I've heard some counties require you to pay the amount in full before they will let you out. And so can you talk about that dynamic and particularly around the pretrial fees and how that affects access to justice and sort of the different culture you've seen around that in the different courts that you've presided in?
Culture does seem to differ some from county to county. Many of our counties, especially those in the eastern part of the state, are more rural, they are poor, and it's quite common for our courts to waive many of the fees about which you've made reference. Electronic house arrest fees, probation supervision fees, and so forth. The attorneys, it's obvious, and they're pleased to us, make that request and expect we're going to do it. And in fact, we do. So if I understand your question correctly, yes, there is some difference in the what you've described as the culture of payment across the state.
Well, and just to clarify, like what I've heard is that
No, sir. I'm sorry.
Okay,
I'm
awesome.
sorry, Mr. I'm sorry. We'll
Thank you,
thank
sir.
you very much. Hopefully, we'll have time to to come back for second questions. Thank you, but we have to make sure everyone gets that turn. Mr. Travis Cook, do you have a question?
Thank you again for your time, Judge. Not at this time. Thank you.
Thank you very much. Mr. Christopher Duggan.
Good afternoon, Your Honor. Listening to your presentation and certainly don't want to peg you into any holes, but do you have any recommendations that could allow for the deterrent factor that some of these arguably do provide, but not escape down that rabbit hole of a constant revolution coming back to court for hearings on failure to pay? Do you have any suggested solutions?
Yeah, I mean, in candor, I think the General Assembly should look at some of these fees and costs and frankly reduce some of them. I mean, they're onerous. They are up beyond the ability of many defendants to pay. I mean, judges do what we can. We as I said, we waive fees, we remit fees, but I think the General Assembly and sometimes the public expects us to impose those. I'm just not sure that's realistic. I think we need to take a good, hard look at the amount of them.
Thank you.
Thank you very much. Mr. Stephen Green, do you have a question?
Not at this time. I do want to thank the judge for his comments. That's all. Thanks.
All right, thank you very much. Mr. Jonathan Guzet.
No questions. Thank you.
Thank you. Jennifer Lechner.
Yes, thank you. And thank you, Judge Locke, for joining us here today. As somebody who is in my personal capacity with the Equal Access Justice Commission, working with the Administrative Office of the Courts on the guide and file interview for 415, I certainly understand the complexity of it. I was wondering if you could offer any suggestions to make that process a little bit easier, especially for pro se litigants who are coming in after the fact to try to either reduce or get waived their fees and fines.
Yeah, I appreciate the motivation behind. Well, I don't know if it's really needed. I think that's why it's probably not used. Pro se litigants just on their own know to come in and ask orally for relief, and attorneys likewise simply make oral motions, and that they will describe for me their client's income and their expenses, and quite often will suggest an amount which they think their client will pay. You know, it's a good form. Perhaps you should have a fewer less entries. It should be a little easier for people to understand, but I just don't know how useful it really is. I don't know how many of my colleagues see it.
Thank you very much. Angelo Mathé, do you have a question?
Yes, thank you so much, Judge Locke, again, for taking the time to speak with us today. I just wanted to go back to one of your earlier points of a potential recommendation of reducing some of the fines and fees. Are there any good metrics out there, either in scholarship or other states and localities, that you recommend that the committee looks at to look at how to potentially provide such recommendations to the legislature?
That's a good question, and I don't know the answer to it. I would suggest that if there is any scholarship out there, you might find it with our School of Government and perhaps some of the similar institutions that exist in other states.
Thank you, Judge.
I did some sort of research into this.
Thank you. Patrick Mincy, do you have a question?
Good afternoon, Judge Locke, and thank you for your time today. I'm interested to know your opinion, based on your experience, about any recommendations you may have, if you had your druthers, on what the General Assembly could do in the sentencing guidelines to give sentencing judges more authority to narrowly tailor fines and costs imposed on any given individual defendant.
Well, there are certain fees that are mandated, such as the lab fee in drug cases. I think we should have the express authority to remit or reduce the amounts of those fees. Likewise, while we routinely will waive electronic house arrest fees, I think we should expressly be given the authority to do so. And indeed, I would think we should be encouraged to do so. You know, we certainly have the authority to do so, but quite often the statute says that we should make findings of fact concerning the defendant's ability or inability to pay. And I'll confess, our findings of fact are often quite cursory. You may say something as simple as due to the extreme poverty or indigency of the defendant, he simply cannot pay.
Thank you, sir.
Thank you very much. Mercedes Restuccia-Clem, do you have a question?
Yes, thank you. Thank you so much today for your testimony, Judge Locke. Could you elaborate a little bit? And you'd mentioned it's complicated, but we haven't heard a lot of testimony, which is why we reopened the record. One reason, at least, was to hear testimony on when civil fines and fees are levied. And you briefly touched upon that. And then the second follow-up is, again, can you estimate about how much time, court staff time, is used in readdressing failures to pay?
Yeah, a lot of court time is used on addressing failures to pay at the time of probation violation hearings. Though, as I mentioned earlier, we seldom impose jail time as a sanction for failure to pay. Typically, we simply will order the probation officer to reset the payment schedule, and we recalculate the amount. I've forgotten the first question you asked. It was a good one.
The first question is if you could elaborate a little bit on civil fines.
Civil, yes. Now, keep in mind, the fines that we impose are not civil. It's just that on a person's termination from probation, the revocation of probation, judges will frequently order that unpaid monies are to be entered as a civil judgment against the defendant. I'll admit I do that quite often too, but I sometimes will look at the types of the unpaid fines and will order that many of them are simply remitted, and typically will order as civil judgments only unpaid restitution. I think I've got the inherent authority to do that even in non-victims' right cases. But I'll order unpaid restitution and sometimes attorney's fees be ordered as a civil judgment. Again, I doubt those civil judgments are actually ever collected. It'd be interesting to know. Perhaps someone has done some research.
It would be. I agree. Thank you.
Thank you. Thank you very much. Gregory Wallace, do you have a question?
Yes, I do. Thank you, Judge Locke, for your very helpful testimony and taking the time to spend with us today. Some have left the impression that there's a good percentage of judges in North Carolina, some have said many, who do not consider a defendant's ability to pay. Has it been your experience that despite the statutory obligations and despite requests by defendants to consider ability to pay, that there are a significant a number of judges who ignore that and move on to something else?
Maybe some, but I do think, Professor, that the overwhelming majority of judges do consider ability to pay, especially in those cases involving huge amounts of restitution, which we will often see in breaking and entering cases or in embezzlement cases and things of that sort. The restitution salt sometimes is in the thousands upon thousands of dollars, and it's unrealistic to expect that a defendant can make that. So in those cases, we do take some time and look at the resources of the defendant, including his employment, salary, and other income and things of that sort.
Thank you very much. Mr. Bradley Young, do you have a question?
I do not at this time.
All right, thank you very much. And I have my final question. Would like to ask, other than fines and fees, what recommendation would you have or would you consider, well, let me say one question. What recommendations would you have other than fines and fees for a defendant to pay?
Thank you for asking that. This might be beyond the scope of our discussion today. I think devote greater resources to our judicial system. We're grossly underfunded, as we are in most states, but more monies need to be devoted to mental health treatment, drug treatment, things of that sort that do tend, I think, to rehabilitate defendants. We should lighten up a bit on the financial obligations and spend a bit more monies that would be paid for in all candor by the taxpayers on treatment of offenders. Again, mental health and substance abuse treatment in particular.
Thank you very much. And we do have a few minutes left. Is there someone that would like a follow-up question?
This is Chris Duggan. Just quickly, Your Honor, when you potentially issue a civil fine or convert it into a civil judgment, those will just expire like any other judgment. Is that correct? After 10 years, it would just end up going away.
That's correct. Yes.
Thank you.
I said I doubt most are ever paid. I've often wondered about that.
Thank you, Your Honor.
Does anyone else have a follow-up question?
Yes, Chairman. This is Daniel Bose. My question is, what sort of standard training is provided to judges on ability to pay by the School of Government, if any?
Very little. I mean, it tends to be mentioned from time to time if the case comes down from the appellate courts in which judge is reversed or because he or she did not consider the ability of the defendant to pay. We are reminded of the obligations, but in all candor, there's very little formal training.
I thank you very much, sir, for your time. We will move on to our final panelist, Judge Hartsfield. Are you available to begin your testimony now? You will have 10 minutes and the floor. Judge Hartsfield, are you ready to begin your testimony?
Ready to begin. I am ready to begin. I thought that I was going to be unmuted. Thank you for this opportunity. Good to see Judge Locke and my other colleague, the district attorney from Randolph today. And let me start by saying that Forsyth County is very different from Randolph and Johnston, and that my district court judge position, again, is one of a people's court situation more than anything. I come from a county that is a one county district, and that is probably 51%, 47% African American, and other, and probably 51. So we're pretty close in our ethnic and racial distribution in Forsyth County. I wish that I were like the colleague from Randolph, but I saw these issues long before COVID. There was mass unemployment. There was all kinds of delays in people being able to get to work and to do a number of things. So the issue of means and ability to pay has been consistent. And before I forget it, even though this was somewhere later in my 10 minutes. I want to talk about that whole civil judgment issue because, you know, things are reduced often to civil judgments. And I think my colleague said that, you know, he doesn't know the rate or if these defendants would even ever have the ability to pay or to own property. Well, it comes back to hunt poor people and African Americans in a much different way. Yeah, probably you don't own any property, but it also affects whether or not you're going to be able to get in somebody else's property, like a public housing unit or like a place where there is a need. It affects a homeless person and to whether or not he's going to be able to move from that homelessness to somewhere else. So even though it may not come out in that kind of distribution that says you can't buy a house, it also comes out to say that you can't live in public housing and you cannot have a house. So the disparate impact is real. I spent my first years as a child support attorney. I worked for DSS. And in that, I had often.
Hartsfield, may I direct your attention back to legal financial obligations, please?
Yes, I'm coming. So the so I was looking at the whole idea of people not paying the child support and what the legal financial obligations were. But it is my belief that from that experience, I was able to see what was really going on. So my testimony about legal financial obligations is that there seems to be a disparate impact on people who have to pay these obligations, and there's simply not enough resources available to help to divert these payments and make other options available. I take, for example, the idea that legal financial obligations are first viewed by a waiver or a financial affidavit. These forms give you some idea, but the veracity and validity of those is very varied and different. We look at a form, they tell you if you're able to work, and this is usually the first phase, because in district court, when I see them, this is when you appoint counsel and do other kinds of things. Once that document has been assessed, then there's some idea just about what you have to do about an attorney in those situations. But that's the first step in assessing legal financial obligations. Post-conviction, I think that there is a lot of discretion of the DA's office and the judge to determine how these legal financial obligations can be paid and whether people have the means and ability to be able to pay those obligations. I think this has to be done on a case-by-case basis. I think that there need to be programs and other kinds of things to help to assess persons who do not have the means and ability to pay and ways to try to help them find it. In Forsyth County, we've had a number of financial obligation helps. We had a delayed payment program, which helped us not to continue the case until the person had the means and ability to pay, but instead allowed us to give them a timeline and a time frame through a delayed payment program that would allow them to set up payment plans with a person who was employed by the clerk's office and through the court. People would make these payments and would be able to do it at something that was not punitive and able to help them. However, the delayed payment program was one of the programs that was dependent upon either the county commissioners or some other entity and wasn't paid for through the administrative office of the court. But it was a deterrent. It did help people not to have to keep coming back to court on the docket. And the only time it didn't come back was when persons did not make their payments and appear once a show cause had been issued. Also, as it relates to legal financial obligations, in Forsyth County, there is a practice that we try to issue show causes and not order for arrest and warrants when monies have not been paid. We have to do it sometimes when people come in and they have failed to make the payments or do the things that they had promised to do. But if you come back, we look at a show cause as opposed to some order for arrest or some other more punitive measures. The inability to pay costs and fees is varied, and it is very onerous and expensive. DWIs are really, really expensive, and the time to pay those. And I think my colleagues have all mentioned another entity that the court really doesn't have that much control over, and that's the three-letter DMV. You know, DMV has its own set of fines and fees and ways for persons to get license back. But again, I think there still helps for that through driver's license restoration programs and other programs that can assist persons in being able to pay these fines and fees. Financial responsibilities post-conviction is very real. And I'll close with just how this is done on a case-by-case basis. In criminal court, a man may be charged with misdemeanor larceny, which is a class 1 misdemeanor. And the facts of the case, which some people pay attention to and others don't, because he may have pled guilty from the start, is that he was in the Food Lion, and in the Food Lion, he stole $21 worth of groceries. The groceries were some ground beef, a can of sauce, a green pepper, an onion, and one other item, which may have been some seasoning. Clearly, he was trying to feed his family and to do it without paying because he didn't have the money to pay. So when you consider means and ability, there's a consideration that not only is there the means and ability to pay these court fees, but there's a means and ability to survive, to live, to feed your family, to be able to do other things that, no, it's not right, and no, we're not advocating for that, but I think those things have to be considered in assessing the legal financial obligation. So what sense does it make for the judge to order him that he has pled guilty to pay a fine of $25 when he stole $21 worth of food because he didn't have enough to buy the food? So what makes you think he's going to have $25 to pay the fines plus the $200 cost? You know, where is it coming from? What do you do? So these are the situations in district court that we are often faced with in terms of trying to look at and fairly assess legal financial obligations. More importantly, I want to close with, as a community and as a system of judges and of community, we sincerely must look at alternatives and other ways we can do this without having to go through the monetary system. We need to look for alternatives, community projects, and community help to help this population. Again, the legal financial obligations that are assessed to minorities and to people of poor economic means have a much different effect in the end. They have a much different effect in the end because even though these may not show up as some incarceration or other, the long-term effects of failure to pay these obligations and failure to not follow through on probation are significant and are extremely punitive and hurt the community, the African-American community, and the lower economic community severely.
Thank you very much for your time and your informative information. And we will now begin with our committee questions. And I will again use the roll call. We'll start with Daniel Bowes. Do you have a question?
Yes. Thank you, Judge Hartsfield. Appreciate you taking time today to speak to the committee. My question is, I know that you were a judge from 2002 until just a few months ago. And so, you've seen many laws created by the North Carolina General Assembly. And I'm curious, there was a period between 2010 and 2016 or 17 where there were several laws passed to basically deter judges from waiving fees, including the report. Can you talk a little bit about that and sort of one, if that's true, that there was this understanding that it was this push from the General Assembly not to waive fees, and what kind of impact that had on judges' willingness to waive fees?
Yes, sir. Very good question, and thank you for asking. Yeah, that did have a big impact on the not necessarily the ability, but the willingness to continue to do it because of the scrutiny that came from it. I know that in our court, the clerk would always write down the waiver of fees. The form had to be filled out, a reason had to be given, and other things. But I think the thing that damaged the most was the fact that that report was published, that there was a list of judges who had waived fees, how many times, the numbers were put into this, and it was viewed as a bad thing. It was viewed as being either ultra liberal or ultra conservative, and the report to the public simply was, some people just don't understand that everybody doesn't have the money to go and pay a $350 fine and fee the same day. But what it did was it caused people to look at what the public reactions were and did not want to be classified as overly liberal or deeply conservative, and it kind of drew a line that was kind of hard to get across. So even though I think that the form for me was never a problem, I didn't mind filling it out. I think that there were some historic and universal reasons for waiving these fees that were apparent and obvious, but everybody did not see through the same lens. And so those numbers became a political enemy to some in a lot of cases.
Thank you very much. Mr. Travis Cook, are you available for a question?
Yes, ma'am. Thank you very much. Judge Hartsfield, again, thank you so much for your time and your very helpful remarks. I have a question about judicial discretion. And one of the remarks you made I thought was very helpful was that when you look into the details of the gravity of the crime, sometimes situations are more sympathetic than others. And I'm wondering to what extent this sort of crime plays into your decision to waive court fees. And when you make such a decision, are you able to look into the details of the particular criminal case, and does that weigh into your decision?
Thank you, sir, and a very good question. Pre-COVID, our dockets in district court probably averaged between 200 and 250 a session. It was basically 5 minutes, let's go, let's go. Most people probably did not have time to even go through a complete docket through all the files to see what it was. But there are some judges, and I try to be one of them, who would ask questions and who would actually look at the warrant to see what the facts were. And I think in those instances, just like my example of the class 1 misdemeanor of the groceries, there were times when it could have been the same class 1, could have been the same African-American defendant, could have been the same Food Lion. But if the consequences were different and the $21 was for a pack of Bud Light and 2 Old English beers, no, probably my result would not have been the same. So the means and ability question would not have been, was this for survival, or was this because your circumstances were such that this was all you could do to feed your family? It would have been different, because it would have thought that if you had the means and ability to buy a 6-pack of beer or 12-pack, and that would be a whole nother story. So yeah, it's definitely case by case. I think that because oftentimes does not permit, and because I think judges come from different economic backgrounds and community backgrounds themselves, sometimes it's implicit. Sometimes you don't even equate the necessity of the situation. But I think that we have a judicial responsibility and a community responsibility to look at these cases to ascertain those facts as it relates to means and ability.
Thank you very much. Mr. Christopher Dugan, excuse me, do you have a question?
Yes, good afternoon, Your Honor. Thank you for your time. I'm interested in hearing a little bit, if you could, for us, that delayed payment program. And DA Gregson, sorry, had spoken about an incentive to incentivize payments. First of all, can you explain a little bit more how that program worked, and then whether an incentivized to early payments, continued payments would end in a write-off of some amount later on? Would that work in that type of program?
Our delayed payment program probably started in the early 2000s. When I came on the bench, there was talk about it. It actually came to be probably in 2003. We went to our county commissioners and talked about the issue of legal financial obligations, talked about the whole idea of continuing cases over and over again to give people time to pay and those kinds of considerations, and talked about paying for someone who actually monitored and set people up on delayed payment. Now, judges had to order people into delayed payment. It wasn't automatic, and there were some judges who didn't believe in delayed payment and would not allow it to be a consequence. But there were the majority who did allow people to pay through DPP. So DPP took you through a process by which you were able to set up payments, make them, how to send them in, how to get them there, and at the end of that period, your case was resolved and everything went away. It decreased a lot. Number one, it decreased a lot of continuances, and probably 70% of the persons who were set up on these programs were able to comply. In the meantime, in the interim, if you had set up a payment plan because you were basing it upon an employment that you had or some other consequences, if in fact your job went out of business or there was a legitimate reason for you not to be able to complete the payments, then you would come back into court. The judge had the option of waiving and saying that, you had paid enough, or, giving you some other options that may be available based on new circumstances. But 70% of the persons who were placed on the program were able to comply.
Thank you very much.
Thank you. Mr. Stephen Green, do you have a question?
Yeah, actually, I was kind of interested to hear, first of all, thank you very much to Judge Hartsfield, but to hear your comments as well as others bring up the issue of DMV and motor vehicle fines as being a significant portion of this. So I was just curious for you to elaborate a little bit more on, I don't know, the ability to tackle that particular portion, how realistic that is, how much of the problem overall that is. Just I'd like a few more thoughts in that area.
Well, I call cases in traffic court, and particularly DWIs, the gift that keeps on giving, because you can look up very easily in a DWI case and your fines and fees may be in excess of $5,000, $6,000. A1s, I think the automatic fine is $2,000. And if you're going to put those devices on your car or any kind of alcohol monitoring devices, CAM, or any of those devices, they can run as much as $120 per day. For a probationary sentence or for a time where you have to do a number of things in order for your car to even crank. These are excessive, but I agree with other presenters that the punitive nature of driving while intoxicated in and of itself, I believe, needs to have some serious repercussions. And if money is one of those, I think for people who can afford the money, even though they may groan and cry, it's still a significant deterrent to have the obstacles that are being placed there. But I'm talking the cost of just not paying a traffic ticket or not doing something that you should have done, that I don't consider to be necessarily punitive, but just human nature and the forgetfulness and people not keeping up with their business and their records, that ends up with you having 2 or 3 driving while license revoked and never having a chance to catch up. Those fees can also be extremely exorbitant. The AOC and a number of other jurisdictions now have drive programs or programs that are offered for people to help clean up their driver's license at some lesser cost than it would be if you tried to go pay all those fines and fees through DMV. But at the end of the day, even though the drive program has worked successfully, in the end, those costs may be lessened by the judge or by some other program that is, but you still have to deal with the DMV end of the deal. And I'm not too sure how you do that. So my advice to people is always try to keep up with your tickets and try to pay them as fast as you can, because it's the gift that keeps on giving. If you don't, it's going to grow and grow, just like the snowball rolling down the hill. But I think that there are some some ways that we can help people even in that situation. And the drive program is one of them.
Thank you very much for that comment. We will go next to Jonathan Guzet. Do you have a question?
Yes, please. Judge, I'd like to know whether in your experience, we heard from Mr. Gregson that sometimes restitution can actually have a positive role to play and help with rehabilitation and reconciliation. I wonder what your experience has been along those lines.
I have seen restitution be not necessarily a deterrent, but something that makes people believe that they got off easier than if they had not had anything else offered to them. I think that a bigger deterrent, and I don't see this, and there are not a lot of programs that deal with this, but in the juvenile jurisdiction, which has a whole nother set of rules, trust me, for restitution and repayment, but there are work it and earn it programs, and there are other programs that are available where you can go work off your time through community service and other endeavors to be able to pay people back. I think by the same token that instead of restitution sometimes, and people that truly don't have the restitution to pay, that there needs to be alternatives. Yeah, for people that have money, I think restitution can be a deterrent because they don't want to keep on paying the gift that keeps on giving. They're like, come on, I can spend my money much wiser and better than this. But if you don't have it from the start, no, restitution is not a deterrent. It's more of an obligation and more of a headache for you to try to figure out where in the world am I going to get it. And we need to start having more kinds of programs and things that can help people deter the whole restitution dilemma.
Thank you very much. Jennifer Lechner, do you have a question?
Yes, thank you, Chairwoman, and thank you, Judge Hartsfield, for joining us today. You've mentioned the DRIVE program. We've talked about the delayed payment program, and you referenced briefly some other community programs that may be able to assist folks with fees and fines. Do you have other policy recommendations for us to consider?
Yes, I think that as a policy, I think that there needs to be more collaboration with the kinds of programs that are out there that can help people move to a better quality of life and self-sufficiency. Those can come through programs that are offered through experiments in self-reliance or other kinds of programs. It is not just, I don't think programs that say, we'll help you pay your fines and fees do any good. Not at all. I don't think that they don't need to be a bank. They don't need to be a lending company. But I think programs that say, hey, you owe this money. We're going to find a way for you to be able to make it, but you're going to have to give some community service back. And I like to analogize this again through cases where community service may be allocated, let's say in an arson case or in a case where there has been a significant fire. And the restitution may be for repayment of whatever was burned or whatever was damaged, but restitution could also come in the form of that person having to work with the local fire department as many hours as it took them to put out the fire so that they could understand what goes on when these kinds of crimes have been committed. And I think those kinds of options need to be available and need to be made policy, or at least for judges and others to have and know about these opportunities to be able to give some deterrence to doing it again, number one, but more importantly, to understanding how these can be costly and affect a larger range of people.
All right, thank you very much. Our time is winding down, so we will move on to the next committee member. Angela Mathey, do you have a question?
Yes, thank you so much, Judge Hartsfield, for speaking with us today. My question related to your statement about disparate impact and how it affected the individuals that came before you. Was that limited just in your understanding to Forsyth County, or did you hear from other judges in other counties about issues related to disparate impact and how it affected communities of color and African Americans in other counties?
I think that it has to do with the makeup of your county. If your county is rural, if your county doesn't have a large number of African Americans or other persons who may be in that community, it's not as probably obvious as it is in the community where I would say on any given day, the majority of the people who use the courthouse are impacted in some way by the fact that they are minority and African American. I say this all the time. Poor people, African Americans, and people who are without use the court system and the public health system and the health system much differently. People use it to come and litigate and to have their voices heard. People use the hospital because we can't say, I'm going to call a lawyer. I'm going to call my attorney. I'm going to bring you to court. Most people don't have an attorney. They're waiting to get one maybe when they come to court. Same with the hospital. I'm going to call my doctor. I have an ailment. I see what's wrong. Poor people and people that don't have means don't have a doctor to call. So what they do is they use the ambulance and the hospital and the ED physicians as a way to getting to the root of their problems. And because the systems are used differently, sometimes the implicit bias goes over everybody's head because you just see these people who you believe are just coming, crowding up the roads and doing other kinds of things and not giving consideration for the impact that it has on later things. You know, it has, for poor people, it has an impact on where you're going to live. It has an impact on whether or not you're going to be able to qualify and get food stamps, whether public services are going to be cut off to you because of this criminal record that has been amassed, whether or not you're going to be able to even get it expunged. And there's even some bias in that people who were placed on programs like deferred prosecution and other kinds of programs that may have a fine and a fee that, again, we have employed over and over again. When it comes time to get those expunged, even though they are dismissals, there's still a cost attached to that for dismissals, for deferred prosecution. Even when you're trying to get it expunged, that's another $175. So the cost given is, it doesn't just end at post-conviction. It follows poor people and African Americans into every endeavor of their life because they are looked at for that record that they've amassed and those fines and fees and things that have not been paid. So I think it's just your community and the economic, what you think about economics. There are judges who believe that you should be able to pay. Once we order it, why can't you go to the money machine and get it? There are others who understand that that's not possible for everybody.
Thank you very much. We have a few more committee members, and I will add 2 minutes to our time so that we can allow everyone to have a opportunity for a question. Mr. Patrick Minsey, do you have a question?
Good afternoon, Judge Hartsfield, and thank you for your time and testimony today. You just referenced a $175 cost associated with deferred prosecution and expunction of deferred prosecutions. That speaks to, I believe, one common criticism of the status quo, which is that many administrative costs to pay for courthouse operations are passed on through legal financial obligations. My question is whether you have an opinion about whether the General Assembly could undermine or take away that criticism entirely by increasing the direct funding of the Administrative Office of Courts.
I will stand up and applaud you. I wanted to do it when you asked that question the last time. Yeah, I definitely agree. You know, the judiciary is an equal branch of government, or at least that's what I remember from my 7th grade civics class. And it sometimes seems like we are definitely not an equal branch of government. And I think that the AOC, in assessing these costs and these fines and fees, kind of doesn't think so either. It seems that way sometimes. And in my county, like I said, we've had to go to our county commissioner, to our board of aldermen, to our mayors and other people to help us to defray some costs and to do some things that will prevent some of this legal financial obligation that we've talked about today, when I think the AOC could eliminate a lot of it. And I think two of the best examples that I can come up with are this. One, the whole idea of class 3 misdemeanors now not automatically being eligible for court-appointed lawyers. All right. Even though that seemed like a gift and it seemed like a good thing, in the end, it's really not. Because what's happening is these people don't have representation. They're coming pleading to these class 3 misdemeanors. Yeah, it's not much time, but these things are going on their criminal record. Again, unless they're programs designed and other kinds of things, they're going to have to walk around with a criminal record that could mean, no apartment, no student loan, no whatever. Then there's the whole idea that we talked about with just the cost that are associated with expungement, period. Because, if you just have a deferred dismissal, a voluntary dismissal dismissed by DA, those are automatically coming off. Now, thank you for increasing our expungement rules. But if you got a deferred payment or some kind of prosecution, for some reason, another cost attached at the end for you to get that dismissed, where most deferred prosecution fees are $200 already for the community service aspect of it. And then when you try to get it off your record because it was ultimately dismissed, there's another $175 cost. It seems to be excessive. And it seems to sometimes be a deterrent while people say, why am I going to do this? Why? Because it's going to cost me just as much to get it off if the fees aren't waived for the community service because I was in school or falls under the other neat umbrellas of the program.
Thank you, Judge.
Thank you very much for this. Thank you. Mercedes Rested-Chocklum, do you have a question?
Yes, thank you so much, Judge Hartsfield. You had mentioned, briefly about how you saw something like 200 plus cases a session, and that was about 5 minutes per, I guess, case, you would say. And our Supreme Court just modified the rule or issued a rule with respect to ability to pay assessment, and it references the form 415 that if a defendant makes a motion and they can use this form 415, then the judge does an ability to pay assessment. I'm wondering, in your experience in that really quick district court settings that you've experienced, how do defendants know to ask for a waiver of the fees, or how do they know, not process, especially if they're pro se, right? Because as you mentioned, class 3 misdemeanors are now pro se. How do they know to ask?
They don't. That's the simple part of it. I learned probably after a long time on the bench that most people don't even understand the judgment. They're just looking to see what door they walk out of. They're just trying to make sure they walk out the back door and not the side door going to court. So they really, if you were to query a lot of people once they leave court and say, what happened? They really don't know. They just know that they're not in jail. And that to them is satisfactory, which leads to people not knowing that they had to pay a fine or that they had to pay a fee or whatever. So the quick answer is they don't. So what happens is that for that form, when someone wants to take up, if there are no lawyers, and the judge decides to do that and tell them about the ability to waiver, anything that you didn't get from the indigency form or whatever kind of goes out the window. That's why it's so important. It's really important for judicial officials to be aware of these things and to understand that sometimes these people just need a day in court and need some pushing. No, I'm not practicing law. I'm not trying to be your lawyer. I'm not trying to be anything, but I think that the availability of these things needs to be laid out at a very early stage of the game. I've seen DAs who were stellar, who told people up front what the options were, told them about, deferred prosecution programs, told them up front, I think you may be eligible for this, you may be eligible for that. By the same token, there needs to be that same kind of advocacy. And because we don't have the ability now to have enough clerks, to have enough anybody to really cover what's going on, really there needs to be a designated person. For a long time in Forsyth County, we had something called a screener's office. And the screener's office would take care of all the people that were asking for court-appointed lawyers and for waiver. They would go through with a fine-tooth comb the affidavit of indigency to determine whether people were qualified for a lawyer. Now, we did that because we were trying to get a public defender's office, and we had to show proof that we deserved one in Forsyth County because we had so many persons who could not afford legal representation. But through that process, we were able to have people who were one-on-one screening people, talking to people about their economic situation that ended in a much more equitable plan to help people with fines and fees. So that's the
Thank
short
you,
answer.
ma'am. We have two more. I want to get in everyone that wants to ask a question. Mr. Gregory Wallace, do you have a question?
Thank you so much, Judge Hartsfield, for spending your time with us today and your very helpful comments. I just wanted to sort of kind of bring things together. What, in your experience as a district court judge, where did you feel your hands were most tied in being able to respond to people who generally could not pay these legal financial obligations? I mean, what thing would you want to change just with your work as a judge and to make things better?
Ma'am, if you could, I'm sorry, please limit your response to 1 minute, please, because we're really running out of time. Thank you.
Yes, I think my hands were most tied with the ability to waive costs and the ability to be able to find alternatives and have enough community resources to be able to direct people in positive ways that could help them with not only these legal financial obligations, but to restore them to a better quality of life in general.
Thank you very much, ma'am. Bradley Young, do you have a question for the judge?
Yes, quickly. Thank you again, Judge. We had previous testimony mentioned that judges were given very little guidance on what to consider about these determinations, about the ability to pay. What advice would be helpful for you in that role, and what kind of guidance would be too much or not enough to help with that determination?
I think that the School of Government for me was an excellent resource. I call Jamie Markham King Jamie because he really deals with legal financial issues, court costs, and those kinds of things effectively. We had a number of sessions as they related to just figuring out what means and ability means. And also, I think that the child support arena gives us even another look at what means and ability to pay from a totally different kind of perspective. So I think that the education is there. Again, I think that the School of Government, particularly for me, was a great source of trying to figure this out. I will say that the Court of Appeals and some higher courts recently, though, have talked about means and ability to pay and have given some guidelines that are pretty difficult to follow and extremely time consuming when you think about the number of cases that come through a court in a day or a court session in a day that require this kind of analysis. So I'm thinking if we looked at other states and looked at other kinds of metrics that are used for other kinds of cases like alimony or PSS or some of those other family obligations, that there could be a formula that could help us determine. But I still think that this is as much gut as anything that we do as a judge, and it's about your background and bias and where you came from. So I think at the end of the day, it's just educating people and helping people understand the nature of being poor, and a whole lot of people just don't get it.
Thank you very much. Your comments have been, I hope, informative for us all. They have been for me. And I want to, at this time, thank all of our panelists presenting today in our web briefing. We will now transition to public comment. First, we will hear from any registered speakers, then we will open the floor to additional public comment as time allows. If we run out of time and members of the public are interested in sharing comments with the committee, please remember we will continue to accept written testimony until March 17th, 2022 at lschiller@usccr.gov, and that information is provided for you. First, I would like to start with any registered public speakers. Is Emily Mister on the call?
Hi, yes, I am on the call.
Thank you.
Thank you very much for giving me the opportunity to speak up. I just wanted to give a little bit of background. I was an assistant public defender in Wake County for 14 years from 2006 until 2020, at which point I joined Campbell Law School and the North Carolina Justice Center, where I am serving as a staff attorney and adjunct clinical professor with the Blanchard Community Law Clinic out of Campbell Law School. We do, I have a lot of experience, obviously, in costs and fines that are assessed in court. As a public defender, I opted to stay primarily in district court, handling misdemeanors. And I had a particular interest and focus on driver's license restoration and how the assessment of fines and fees led directly to the suspension of people's driver's licenses, which then, of course, plunged them into a cycle of continued inability to get jobs, housing, etc. I would like to take an opportunity to kind of address a couple things that the panelists spoke about regarding the 415 form, which was released, I believe, in 2020 as a tool for individuals to request waiver of costs and fines, both at the disposition of the case, initial disposition, but also post-conviction. And I think it was generated partially in an effort to make it easier for folks to request waiver of costs and fines to get their driver's license restored. And since I joined Campbell Law School's clinic, we have filed those 415s in a number of jurisdictions across the state. Unfortunately, because it's such a new form, we've had some difficulty getting policies or processes in place in some of those jurisdictions. And so it's not uncommon for me just to not hear back from a jurisdiction at all. I think the form is necessary. I do agree that it is cumbersome and complicated. And I mean, I probably need an accountant to fill it out. And so certainly the pro se folks do. And I'm excited about the guidance file. But I do think it is a very important process to get in place for people to request relief. I also wanted to speak.
Excuse me, you have 1 minute left to conclude. Thank you.
Thank you very much. I also wanted to speak briefly to the processes around the state. I understand that courts, the Superior Court judge spoke about his colleagues' willingness to make those inquiries. I can tell you in district court in Wake County, those inquiries were very rarely made. If a defendant brought it up themselves, which was unusual because pro se defendants don't usually know that they have the right or ability to do that or the ability. And as an attorney, I only brought it up in situations where the person would have some sort of collateral consequence for non-payment, such as suspension of driver's licenses. District court judges blatantly told me regularly that they couldn't remit everyone's costs and fines, even though I only represented indigent clients. I also wanted to point out that there are a number of jurisdictions across the state that still to this day issue orders for arrest for non-compliance with monies owed. And those include Edgecombe, Nash, Cabarrus, and Duplin. I believe Alamance also does that, at which point they literally issue orders for arrest for non-payment of fees and fines on traffic offenses, which is, in my opinion, a debtor's prison.
Has passed.
Thank you.
Thank you very much for your time. Are there any, that concludes our list of registered public speakers. I would like to ask the CenturyLink operator if there are any members on the public line.
And currently, there are no members on the public line, but I will make a comment that to ask a question or make a comment, you can press *1 if you'd like to make a comment or ask a question. And currently, we have no one in either queue to ask a question or make a comment.
Okay, I would like to thank all the committee members and panelists. That will conclude our public comment section at this time. Now I will ask any committee members if there are any follow-up questions that they have. Our panelists, I do see Judge Hartsfield. Are there any other panelists still available for questions?
I'm still here, Mr. Gregson.
And I don't know. Okay, thank you. Thank you very much. Does anyone have a follow-up question at this time?
Chair Wright, I actually wanted to ask the panelists if they wanted to respond to some of Emily's comments. So to the panelists, just from what you heard from Emily, do you have any responses to that?
No, we will not ask the public comment questions.
Okay.
The public speakers
Forgive the
questions. Thank you.
interruption. This is Victoria Moreno, the designated federal officer. I just wanted to point out to Chairwoman Morgan Wright that there are also members of the public on the WebEx call. If you'd like to check in to see if any of them would be interested in providing a public comment.
Are there any other members on the WebEx call that would like to present a public comment at this time? Would the operator connect them, or would it just be the #1?
If anyone would like to provide a comment, you can use the raise function, the raise hand function next to your name to indicate your interest. Or you can also, you do have the ability to unmute yourself.
If there is anyone present that would like to make a comment, please do so at this time.
Chair Wright, I wanted to ask DA Gregson or Judge Hartsfield.
I'm sorry, who's speaking?
This is Daniel Bose. This is Daniel Bose.
All right.
I wanted to ask any of the any of the panelists about orders for arrest based on non-payment of fees, and specifically, you know, that's been it seems like a practice that is still around, but is much less in use than it used to be. Can you talk about that evolution and your experience with orders for arrest based on non-payment of fees?
Mr. DA, you want to go first?
Yes, ma'am, that's fine. I've been a state prosecutor since 1994. I can't recall that we've ever done that in Randolph. For a time, we were the DA in Montgomery and Moore County as well. I cannot recall that we've ever done that.
In Forsyth, I can say that we have ever done it. Yes, we've done it. But basically, ours come from OFAs or failure to appears where, you know, it's been issued and nobody shows up. And those cases, yeah, if you show up because you've been issued with it, it's a rare day that anything's going to happen from it. And I think I talked about the emphasis on show causes instead of even issuing orders for arrest or such other kinds of entities, so that somebody does have the opportunity to come into court and show cause why they did not have the means and ability to comply with what had been ordered by the court for legal financial obligations. So it's getting better.
Let me add to that. That doesn't mean there wasn't consequences, because if it was a DMV case, they were typically reported to DMV. But I don't recall us ever issuing order for arrest for that.
Thank you.
Does anyone else have a follow-up question of our panelists? All right, I would like to thank all committee members, the panelists especially, and members of the public who participated today. We will continue to accept testimony, written testimony for this briefing until March 17th, 2022, and invite you to join us at our next briefing on March 15th, 2022. This briefing will also focus on LFOs from a research perspective. And at this time, I will thank you all again for your time and your participation, especially the panelists. I hope we all learned from this experience, and today's meeting is adjourned at 1:52 p.m. unless Victoria Moreno has other information to share.
No, Chairwoman, thank you to all of the panelists, committee members, and members of the public for your engagement. If you would like to submit written testimony, you have until March 17th at the email on your screen, lschiller@usccr.gov. Thank you, everyone.
Thank you very much. The meeting is adjourned.
Thank you.
Have a good day.
Good day to everyone.
Thank you. You also. Thank you so much for your time.
Thank you.
Thank you.
And hello, this is the CenturyLink operator. Is it okay to disconnect the line?
Yes, you may. Thank you
Yeah.
so much, Orlando.
You're very welcome. Have a